if you're going to be buying or selling property in California, residential property, and you're a listing agent, a buyer's agent, a broker, a buyer or seller, you should watch this video. My name is John McConnin. I'm an attorney and a broker. I've been both for about 20 years as a broker and longer than that as an attorney. And I've done a lot of real estate. In fact, Carr had me train real estate agents in multiple offer negotiations and contracts. So here we are with the California Residential Purchase Agreement, and I want to draw your attention to G3, and I'll then explain how this transaction is going to go. So in the scenario I've been using, 1-1 listing price, negotiations back and forth, including an SPBB, which is where a separate agreement where buyer agent compensation is discussed and then eventually memorialized. So let's say that the buyer sends over a form with this, and the terms are all met at $1 million. Everything else they've agreed to. Seller's like, great, I'll agree to this, but I no longer want to pay 2%. What's the listing agent going to advise them to do? Well, they're not attorneys, so they probably shouldn't do this, but they'll send them to my video or someone else's and say, well, what you could do is sign this agreement as it is from buyer and cross that out and initial it. Or I can draft you up a counter if you advise me to do so without that in it. Now, I would do that every time. Like, there's no question to me that if I'm a seller, I'm taking this out every time, right? Because I might negotiate that other thing separately. And if the buyer agent wants to break their fiduciary duties and hold up the transaction and the buyers are going to let them do that, fine. But let's just remind you that there's going to be lots of pressure on the buyer's agent because the Department of Real Estate says that the fiduciary duty of a buyer agent is to never put the client's interests, never to put their own financial interests above the client's. That is the fiduciary duty of a buyer's agent. As a lawyer and broker, I've always been concerned about this from day one, and so has Phil in my office, who's a realtor. So this is insane. This is an insane thing that we're trying to do with these new terms. So it's almost, I'm wondering, and it may rise to a level of duty, the listing agent may tell their sellers that they should never, always cross that out on the way back and then deal with that on the separate issue. So you counter, you get to the price, it's $1 million, buyer's now ready to go, and let me just bring it back. But the listing agents go, well, what about me? What about my agreement? You owe me 2%. And the buyer can say, look, I don't have 2% for you. Are you really going to hold up my transaction so you can get paid? I don't have the 2%. What's the buyer agent going to do? Well, he or she is going to go back here. I got to move this. I'm going to press no. And I'll pull up the SPBB. This is the S. That's different. This looks like the SPBB. So now, this is the SPBB. The following terms and conditions are hereby incorporated in and made part of the purchase agreement. I think, in my opinion, doing this, like I'm an attorney and a broker, I've thought about this. I'm going to roll out, I do believe lawyers and homeowners and home sellers can make unilateral offers of compensation. And I believe that they can empower their fiduciary to do so too. So we're rolling out a whole course and forms and everything to advise sellers on the risks, talk about how we can mitigate the risks with these forms. We'll have this buyer sign these forms, and I'm also going to say why I've been doing this in my videos since this first came out, why this all goes away if we put lawyers on the buyer's agent team, because it'll stop DOJ in their tracks. But anyway, that's coming soon. But let me just say that the following terms and conditions are hereby incorporated made part of this agreement. As a seller, I don't ever want this jumbled up. I might say other and agree, as a separate matter, if the property, I'll name the property, if it closes, I'm not gonna do the legal terms because I have to think about it more, but I will authorize escrow to pay X% or $5,000 and I will deposit it into escrow. Like, I would do that, but I'd always keep this separate. I would not include this as part of the purchase agreement. It's smoother, it's cleaner, and increases your leverage, and it actually helps out the buyers. They're going to have more flexibility to close if you do it this way than if you keep bringing it back with that checkbox saying it's incorporated. Like, I don't know why anybody, just me, why, if you're trying to sell your home, why would you worry about these agreements because NAR and CAR got themselves in a pickle? No, you negotiate for the sale of your home and the terms that are on that agreement. And if the realtors can't put the terms in there, then so be it. But don't blow up your own deal to help the buyer agent. Just always make it separate. This is just a separate deal that you may or may not sign. All right, my name is John McConnin. That's how I see it. I think every buyer's agent knows that this is likely to happen. Listing agents, you really should have an attorney on your team because I'm going to show you, or other attorneys could show you, but I'm setting up the whole program, how to broadcast unilateral offers of compensation, because I am not buying into these agreements. And then after we get enough people, like I really want to get a lot of people involved, we got to go to the legislature and not let NAR and CAR change these rules, right? They got themselves in the pickle because they were trying to help people, really realtors, and really their big brokerage clients who were their main owners and controllers, make as much money as possible without bringing lawyers in. As many other states have lawyers in these deals. Like these deals, had lawyers been there, in my opinion, this would never have happened. This is an absence of attorney advice around all the conflicts that these agreements make. And if you think about it, these agreements were so designed to help realtors practice law without a license. Like they should have just said, hey, this is, lawyers are involved in contracts. All right, so my phone's ringing. I'm going to go. Just look. I'm going to say I don't have the court's not going to be there eventually. But if you're interested, it's let me just make sure I have it. It's I think certifiedsellersadvocate.com. Certifiedsellersadvocate.com. No, that's not it. Maybe I spelled it wrong. Seller advocate? No, I spelled certified wrong. Yeah, I'm going to change the front page eventually, but this is where you're going to be able. Oh, got to bring it over here. So right now, I started it. This is going to be where initially realtors can find out how we can help them. I'll have webinars in there, and then we'll be making sure your sellers are educated and the buyers are educated as all part of a program. And I think the offer I make, I'm almost trying to make it like it's an offer you can't refuse. It's going to be so good. It's not going to be that much money, and the value you get will be far beyond what you're expecting. Anyway, my name is John McConnin, and I really feel that buyers and sellers need to be educated, and listing agents and buyer's agents, you don't have to be hamstrung by these CAR rules. And as you know, right now the MLS is going to be a big issue. I don't see the MLS being a big issue. This stuff's already kind of been litigated in California. They're supposed to be separate from CAR, and that's why you don't have to be a member of NAR and CAR to be a member of the MLS. I don't think the MLSs have the power to do this to people. Like they're trying to hamstring you into these bad agreements, and they're being sued in Michigan. So once again, that'd be certifiedselleradvocate.com for more information when it's up. Thanks. My name's John McConnin. I'm an attorney and a broker.